Here with us today are three esteemed colleagues. Adam Kissel is a visiting fellow on higher education reform for the Heritage Foundation. He is also a senior fellow for the Cardinal Institute for West Virginia Policy and a visiting scholar for the Texas Public Policy Foundation. He previously served as a Deputy Assistant Secretary for Higher Education Programs with the United States Department of Education. Adam currently serves as a chair of the West Virginia Professional Charter School Board and is a member of the Civics, History, and America's Future Advisory Council for America 250. Adam was recently appointed to the University of West Florida Board of Trustees. We also have Gail Harriet, who recently retired from her tenure of Professor of Law at the University of San Diego. Gail has been a member of the United States Commission on Civil Rights since 2007. She's also the Executive Vice President of Californians for Equal Rights Foundation and chair of the American Civil Rights Project. Early in her career, Gail practiced law at Mayer, Brown, and Platt in Chicago and Hogan and Hartson in Washington, D.C. Gail also served as Civil Rights Counsel to the U.S. Senate Committee on the Judiciary. She served as Associate Dean and Professor of Law at the George Mason University School of Law. Last but not least, Dan Marnoff is the founder, executive director, and secretary of the American Civil Rights Project. Dan has practiced law in the private sector and served on the legislative staff of Senator Phil Gramm. He is also an adjunct fellow at the Manhattan Institute. He has also served as an officer or director of a number of community organizations in Dallas, Texas. Without further delay, let's start our forum, the purpose of which is to understand the history, present, and future of Hispanic serving institutions as a federal designation. My first question is for Adam. You served as Deputy Assistant Secretary for Higher Education Programs at the Department of Education. During your time in the federal government, did you see an expansion of minority serving institutions programs, including Hispanic serving institutions? Give us your sort of 10,000-foot view of the Hispanic serving institutions program. Is it, in your opinion, a good policy? How has it evolved in the last 2 decades?
Thanks so much for having me. Welcome to everyone who's watching and listening. So the Education Department has no one program that's called the Minority Serving Institutions Program. We split the higher education grants into a variety of teams. And for today, we're just discussing the institutional grants, what the Education Department calls the institutional service, as opposed to grants for federal TRIO programs, college preparatory programs, which get called under the heading of the student service. So in the institutional service, we have Higher Education Act programs, grant programs, under Titles 3 and 5 of the Higher Education Act. And that agency, that part of the agency also just got HEA Title 6 for international education programs. Title 5 is the part that we're going to talk about today, the Hispanic Serving Institutions, or HSI programs, whereas Title 3 is for HBCUs, historically Black colleges, as well as the quota-based programs based on race or national or cultural origin that also live inside Title 3. So a minority serving institution is defined really as any institution that qualifies under Title 3 or Title 5, except that HBCUs are kind of a special case. They're more or less fixed for all time because they're defined historically. They're historically Black colleges or universities. Now that's still a racial categorization because they were historically Black and not something else, but they could be an all-white historically Black college. So today, HBCUs are kind of off the table from the minority serving institution discussion for today, I think. The only way to add a new HBCU is to find one that went out of business and bring it back to life, which I think has actually happened once. And there's an incentive to do that because it brings you a bunch of money as an HBCU. The other MSIs become eligible for funding on the basis of having enough students of the designated identity group. So for Hispanic serving institutions, a college needs to be 25% Hispanic to be eligible. There's other categories under Title III. You need to be 40% Black to be a predominantly Black institution. You get eligible for the AANAPISI, the ANAPISI grants, if you're 10% Asian American and Native American Pacific Islander. If you're 20% Alaska Native or 10% Native Hawaiian, you qualify for ANNH grants, the Alaska Native Hawaiian Serving Institute. So you can see that every identity group from a racial or ethnic perspective has found its place in the Higher Education Act. Now, you do need some other qualifications. Your students have to be low income enough to be a predominantly Black institution. You have to have 1,000 students or more. Of course, you have to be an accredited institution, which is a whole separate conversation. And again, for today, we're just talking about the qualification based on racial or ethnic quotas. Now, if you read the Higher Education Act, there's a preamble to Title V, and you can find it at 20 U.S.C. 1011. And Congress states its findings that supposedly justify the HSI programs. One of these, and I'm going to quote, Congress has told us, quoting, disparities between the enrollment of non-Hispanic white students and Hispanic students in post-secondary education are increasing. Now, this was written in 1992, maybe 1995. So it's a 30-year-old set of data that justifies the HSI programs. Second sentence, between 1973 and 1994, so this is written in 1995, enrollment of white secondary school graduates in four-year institutions of higher education increased at a rate 2 times higher than that of Hispanic secondary school graduates. Probably it's the opposite now because of demographic change, and I don't know what the actual numbers are. Lots more Hispanic students have been entering the United States and going to college. So although Congress has not updated this 30-year-old statistic, we still have the HSI programs. Another thing to know is that HSI funding is for the whole institution, not for programs that are intended to have disparate treatment of Hispanics by race. So colleges can use the money for anything that's capacity building, could be endowment. Up to 20% of the dollars could just go straight into endowment. But there's a bunch of other things. It could be library books. It could be programs that have to be open to all students. But the point is that the programs have a disparate impact on Hispanic students. Otherwise, the dollars wouldn't be around for HSI programs in the first place. So if you're interested in the disparate impact, every HSI program is a problem at every institution because the whole point of it is that you're making it easier for Hispanic students more than for other students to be there. But it's the racial quota that's really what I think others are going to talk about. So from a perspective of disparate impact, the better the programs do, the more illegal they are. So are they good policy or not? Well, they have perverse incentives on colleges to discriminate. So just taking a quick last example before I turn over the floor, University of Nevada at Reno said, one of our top priorities is to get the money, our part of $350 million a year for being an HSI. It's our top priority to become an HSI. So we're going to give students $10,000 across their junior and senior years if they major in Spanish and a second thing. And the bet, based on a stereotype, is that Hispanic students more often speak Spanish. They're going to disproportionately benefit. They're going to come to our institution and we'll become an HSI. And look, Congress gives $400 million a year to HSIs. There were 200 of them in the 90s. There's more than 600 of them now. And you can get $600,000 a year if you're an HSI. So it's real money. And the perverse incentives cause you to change your program's policies, even admissions, in order to get this status and then to keep it. So that's enough for now. It's a good introduction to where we are on HSIs. So I'll give it back to the chair of our meeting.
Thank you, Adam. I have a quick follow-up question. So do schools that have been awarded HSI grants have to submit reports on how they use the money to benefit, grow, and target Hispanic student populations in their institutions?
Yeah, so there's 3 programs. One is called Developing Hispanic Institutions. That's parallel to the other developing institutions programs across Title III. And on the front end, you have to apply for the money, say what you're going to do. And then on the back end, you have to say, this is what we did. And along the way, you have to draw down the funds over the course of your year. And that needs to be sufficient from a 2 CFR 200 point of view. In other words, all of your accounting, and you have to actually be spending the money on what you promised. So those reports are out there. They might be very cursory because what got you the grant is just you already laid out what you were going to do. And there's not a lot of follow-up on the back end to make sure you did it. But there are site visits from time to time, and you might have to prove your accounting and programming that you did the things and are continually doing the things you said you would do.
Thank you. And most of these grants are over 3 years. Is that correct?
They can be 1 to 5 years. There's a post-baccalaureate Hispanic Serving Institution program, and then there's an HSI STEM program. So each of these is on its own timeline.
Got you. Thank you. So Gail, HSI designations were added to the Higher Education Act in the 1990s. Your group, the American Civil Rights Project, has made this argument that these programs violate the Constitution. Can you elaborate on this?
Yes, I can. And I think this is basically the core question that we have to be dealing with here. You know, are the HSI programs unconstitutional race discrimination? Let me deal with a little bit of background in how the Constitution works when it comes to the issue of race discrimination first. I'm not going to go into it in great detail. It's more like this is what every law student learns in constitutional law. And that is, if you look at the Constitution, the 14th Amendment, actually doesn't use the term race discrimination, and neither does the Fifth Amendment. That term is not in there. But the Supreme Court has rightly interpreted these parts of the Constitution to forbid most race discrimination. That race discrimination, in fact, is a particular concern of these amendments. And so the Supreme Court has developed a way of looking at the issue of race discrimination. They use a standard that they call strict scrutiny. And strict scrutiny can be described in several different ways, but the basics of it are that if you have a statute, a regulation, a government program that discriminates on the basis of race or ethnicity, number one, the government has to have a compelling interest in order to do this. And that, accent on the word compelling. There has to be a really good reason for this. And number two, the particular statute, regulation, government program has to be narrowly tailored to fit that compelling interest. And if you hear that standard and you think, well, just how strict is strict? And for a while, the leading constitutional scholar of the 1960s and 70s, a guy named Gerald Gunther, he wrote the textbook that students use on constitutional law. Back in the 70s, he said, look, the strict scrutiny standard is strict in theory, but fatal in fact. And that means everything flux it, everything. If you've got race discrimination, it's going to be unconstitutional. And, over time, the Supreme Court loosened up a little. So you really couldn't say it was always going to be fatal, but they're tightening it up again. And even under the slightly looser version that Gerald Gunther, didn't see coming in the 1970s, even under that slightly less strict scrutiny, this program would still flunk. So let's talk about what the possible compelling interest can be for a program. Well, actually, belay that. Let me ask first, is this really race discrimination? Is this really discrimination based on ethnicity? Because some people look at it and say, well, it doesn't work at the individual level. It's not like something is going to individual students who are of a particular race and not going to people who are another race. Instead, the money goes to the institutions. But think about it. I mean, the rule I like to use is flip it. If you had heard that Congress had started a program that colleges and universities can only get a particular, funding if at least 60% of the students are white, you'd faint, wouldn't you? You'd think that just can't possibly be constitutional. That just cannot be constitutional. And right, it's not. And that, I think, drives home the notion that just because you write the check to the university, that doesn't mean that it's not race discrimination, that it's not ethnicity discrimination. You know, what's happening here is that money is going to institutions based on the race of the students, based on the ethnicity of the students. So we're at the point where we say, okay, yes, this is race discrimination, this is ethnicity discrimination. Does it survive strict scrutiny? Okay, what possible justifications can there be for the HSI programs? Number one, you could say that Congress possibly has a compelling interest in making sure that low-income students can get a good college education. Makes sense, makes sense. That's certainly important. The trouble here is that this is by no means narrowly tailored to fit that. If Congress wants a program that benefits low-income students, and they have some programs like that, of course, but they should be doing it based on the actual income of the students. We all know that there are Hispanic students who are better off, Hispanic students who are worse off financially. There are white students who are better off, white students who are worse off, and the same for every race. It just is not narrowly tailored to fit the requirement of narrow tailoring. It's just not. So what else might be a possible compelling interest here? Another idea one could have is that Congress has a strong interest, maybe compelling, that students for whom English is not a first language, that they are in a position to where they can get a college education and that they can become fluent in English as the dominant language of our country. Whether that's compelling, we don't need to decide. It certainly would be a plausible reason, but again, the HSI program is not narrowly tailored to fit that purpose. It doesn't come close. We all know that there are Hispanic students for whom English is the first language. There are Hispanic students for whom English may be a second language, but they're nevertheless fluent. There are white students for whom English is not a first language, in which they are not fluent. There are Asian students who are not fluent in English. If Congress wants a program that's aimed at bringing college education to people who are not fluent in English and also making them fluent in English, they cannot just do it based on the ethnicity of the student body. It's not narrowly tailored. Flunks. Okay, so what are the other possibilities here? One possibility that was stronger a few years ago than it is now, at one point, after Gerald Gunther said that strict scrutiny is fatal in fact, the Supreme Court surprised him in the case of the Regents of the University of California versus Bakke. And they said that the desire for diversity, can be justifiable here. And the Supreme Court's cut back on that. In the recent case of Students for Fair Admissions versus the President and Fellows of Harvard College, the Supreme Court backed away from the notion that diversity could be a compelling interest. But even if they hadn't backed away, even if they hadn't, even the Bakke case, even the cases that were soft on the notion of diversity, they were very clear that quotas are not constitutional. And the HSI program is all about a quota. A school has to have 25% Hispanic students. If it has 24%, that's not good enough. It's got to be 25. Moreover, there's no diversity issue here, even if it wasn't a quota, because a school can be 100% Hispanic and they still can become an HSI. So it actually doesn't work to ensure diversity. So for many reasons, including the fact that the Supreme Court just 2 years ago has backed away from the notion that diversity can be a compelling interest. It's not going to work here. It's just not going to work. It wouldn't work. It doesn't work under the students for fair admissions case. It doesn't even work under the earlier cases that were softer on that issue of diversity. It just won't work. So those are the three most obvious ways in which someone could argue that the Hispanic Serving Institutions programs are constitutional. And I think the response argument is overwhelming, not going to work. Adam brought up the historically Black colleges and universities program, the HBCUs. And many people have asked me, well, if HSIs are unconstitutional, are the HBCU programs also unconstitutional? And I think, as Adam was hinting there, they're on a different basis. And the argument that in favor of HBCUs is stronger than the argument in favor of HSIs. HBCUs are historic. And the idea here is that these were universities that in the past were shortchanged in the amount of money that they received from the federal and state governments. And that was an unconstitutional point back in history, and that now we're making up for it. Now, you can't make up for it forever and ever and ever. But when it will become a problem, that's in the future. That is not the argument that's being made today against HSIs. HSIs are much more obviously unconstitutional from the get-go. It is not necessary to be an HSI, and no one requires that there be proof that an HSI has been shortchanged in the past. Some of these schools weren't even established until long after the Civil Rights Act of 1964, long after Brown versus the Board of Education, long after any point at which schools were being shortchanged because of the race of their minority students. And as Adam says, one nice thing about HBCUs is they have no incentive to discriminate on the basis of race, no incentive whatsoever. An HSI has to be able to certify every year, yes, we have enough Hispanic students for the money to keep flowing to us. And so they have every reason to discriminate on the basis of race. That's not true for HBCUs. They are often wide open to students of every race, and there are HBCUs that are majority white. So that's a different case. We're not addressing that case. It's a harder case, and certainly at the time HBCUs were established, they were constitutional, and my view is that they still are. But that that will change at some point in the future. You can't go on that way forever. But for HSIs, I think we have a very strong argument that they are unconstitutional.
Thank you, Gail. Speaking of the court of law, Dan, Students for Fair Admissions and the state of Tennessee recently filed a lawsuit against the federal government to challenge the constitutionality of HSI programs. Your group, the ACR Project, filed a motion on behalf of the National Association of Scholars and faculty, alumni, and students opposed to racial preferences to intervene and join in the lawsuit. More recently, the U.S. Department of Justice announced its refusal to defend the program. Can you walk us through all these moving parts?
Yeah, absolutely. I'd love to. Before I jump into that, I'll just flag there's one other exception to what my predecessors have been discussing, that in addition to how HBCUs really aren't like the other so-called minority serving institutions programs, there's one other that is also a little bit different, that being tribal colleges and universities. Tribal colleges and universities are the public schools run by sovereign Indian nations. So when they have programs that prefer their constituency, the members of their tribe, that's really more like the University of Georgia charging a different amount for in-state students than out-of-state students than anything else. It might look like it has something to do with dissent, but our Constitution and our con law is very clear that tribalness is a different thing. So I just want to be clear, we're also not talking about that. It's everything else that we are, all of these 9 programs, the HSI programs plus that make their funding conditional on the racial balance of the enrolled students. Yeah, Tennessee and SFFA filed this case, and their main argument, their central argument, is that Congress doesn't have the power to fund anything like this. They say that it doesn't, that this is not spending on the general welfare because it's particularized for a specific group, and that it incentivizes violations of the 14th Amendment. The 14th Amendment is what Gail had mentioned, the provision of the Constitution that the courts have looked to say, yeah, racial discrimination is unconstitutional when engaged in by the states. The way they've done that is by using the clause of the 14th Amendment called the Equal Protection Clause, and says it doesn't equally protect people to classify them by race. So basically, there's this whole line of other cases, which I won't bore you with the details of, but which say, look, Congress can do an awful lot with its spending power. Congress can spend money almost any way it wants to, but there are some limits on how Congress can spend money. One of them that's always mentioned is the independent constitutional bar doctrine, which isn't as complicated as it sounds. It basically just means if something is unconstitutional for a funding recipient to do, Congress can't say you only get money if you do it. And they always give 2 examples: denials of due process and invidious discrimination, which again is here a violation of the Equal Protection Clause, which we know from the Harvard case discrimination in admissions would be. So they also make a few other arguments. They say that basically state institutions are given a Hobson's choice here: either discriminate in violation of the law and the Constitution, or get denied access to money, and they shouldn't have to make that choice. They also point out that there are elements of the program which, in order to qualify, you would actually need to violate state law, and that violates the state of Tennessee's rights as a sovereign. So there's some other issues there. SFFA, Students for Fair Admission. It's a national organization. It has members all over. Those members are mostly students. They also include faculty. That's worth mentioning because at least one of their members is actually a faculty member at a school in Tennessee that would qualify for HSI funding, but for the racial balance of its students. And these are the arguments that they're making. There are 2 interventions that have actually been filed. One is ours. We make all the arguments that Gail was talking about, as well as the spending clause argument that I just kind of outlined. We also highlight that larger set of programs that, while at issue in this litigation is only the HSI programs, there's actually this larger set of 9 programs, those in the HSIs included, which cumulatively spend about $1 billion a year in grants. So since the issues are the same, the court should bear in mind that they are. We have argued that it harms students to have their school denied funding because of their races and those of their classmates, and that it harms faculty to be denied funding for their work or for their facilities because of the races of their students. That it also actually harms faculty in the hiring process to have out there this element of the HSI programs, which I swear to you is actually referred to as servingness, which in no way should be a word in the English language. But schools are supposed to demonstrate that they have servingness, that they do serve Hispanic students. Well, how? Most of the consultants out there who are trying to help schools access this turret of federal money are telling them that the answer is that you should make yourselves more welcoming to Hispanic students. And how should you do that? By having a faculty that demographically matches the targeted student enrollment. But there's no exception to Title VII, which is our generalized employment law, allowing schools to discriminate on the basis of race and who they hire and who they promote in order to create a match. That's just not a thing. So this is another way that the programs are incentivizing illegal behavior. Um, I do want to point out one detail also where I think I may disagree with Adam slightly. There's actually a statutory and regulatory provision that requires that the grants of the HSI programs be spent to benefit Hispanic students and others. Now that and others is there, so it does not require exclusively that spending benefit Hispanic students, but it does require specifically benefiting Hispanic students, and anybody else is a throwaway added on, which does mean, in fact, that schools to participate in this program have to pitch grants that show that they're specifically designing programs to benefit a racially defined group, and then report back that they've achieved that, which sounds an awful lot like the kind of disparate treatment that that our law makes unconstitutional for public schools and illegal for any federal funding recipient, even aside from everything else we're talking about. Um, those are the arguments we're making. There's a second intervener. The second intervener is the Hispanic Association of Colleges and Universities. This is an organization that was created in the 1980s. A bunch of colleges got together, basically because they wanted to lobby for money specifically for themselves. Uh, the categorization they came up with for the people who happened to be in the room was that they all had enrollments that were 25% Hispanic. So they started lobbying for Congress to create a torrent of money that would go specifically to schools that were all at least 25% in their enrolled students Hispanic. That really is the history here. And it really is that directly special interest, the lobbying in play. They eventually, in the 90s, convinced Congress to pass this and to create something that gave them money. Now, they didn't include some sort of historical, backward looking element in the definition. So others have been able to join the club. And that sets up a very strong incentive for anyone to do so, which is why there are schools like the University of Nevada, Reno, that are telling us we are doing these things because we want access to the money. Whatever else you think about any interest, accessing federal money is not a compelling purpose. I guarantee you that that cannot be sufficient to get you out. But regardless, hack you. They are apparently intending to make two arguments. One argument is that the plaintiffs, at least the existing plaintiffs, they say don't have standing here. That's a standard rule that only affected parties can bring litigation in courts. It's a way for courts to avoid being asked to issue advisory opinions. The second argument they want to make is that nothing about these programs violates rights, privileges, or immunities, which is an interesting statement because no one has argued that they do. The argument is that they deny equal protection. There is a privileges and immunities clause of the 14th Amendment, another one in the original Constitution. They're not at issue here. But these are the arguments that they seemingly want to make. We'll see what happens. As you mentioned, the Department of Justice in the meantime has said, we will not defend the Hispanic Serving Institutions programs because they deny equal protection. Since that's very clearly one of the claims that we've asserted, I'm glad to hear it. And that's where things stand. The Department of Justice's deadline to actually answer in this litigation is right now October 2nd. They haven't done it yet. We'll see what they say. I think we know from what they told Congress. And we don't know yet what the court is going to do with those intervention motions. I think it's probably a good bet when the existing defendants have announced they won't defend, that the court is going to let them in. If they're letting them in, I think it's extraordinarily likely they'd let us in as well. We'll find out. But that's where things stand currently in the litigation.
Thank you, Dan. Going back to the policy aspect or the policy substance of these issues, are there any viable or better alternatives to awarding federal grant money based on student demographics, so based on race or ethnicity? If HSI were to be ended as a federal designation, what would the federal government do to better target and assist individual college students based on needs.
Sure. And I mean, I guess I'll throw out in the first instance that what the existing plaintiffs and we have asked the court to do is to blow out the discriminatory provisions of these programs and to just take that out, at which point the other statutory provisions would be what remained, and the program could in fact continue. Now, whether that's the relief a court grants, that's a separate question. We'll find that out in due course. But entirely aside from what can a court do about this, there's the larger question of what could Congress do about this? Like, is there in fact something better Congress could do? And I'll tell you, I've written a model bill. It's kind of a choose your own adventure novel, giving Congress a whole set of potential options that they could use to replace these very clearly discriminatory programs. Our version gives, I think, 4 to 6, depending on how you count, models for how you could replace this with something that would be better and very clearly legal. The first of those is to say that Gail had mentioned that if Congress wanted to, it could spend money specifically to help at-need students access a college education. Congress has done that. The Pell Grant program has existed for decades. It measures ability to pay, and it gives money to students to help them pay to go to college. Easy enough. You could expand the Pell Grant program. You could make it literally larger. You could put all this money into it. You could increase the maximum amount of a Pell award to cover some of the rampant tuition inflation that administrators have created over several decades, to make it much more meaningful to help people actually pay for their schooling. A second option we gave, also building on something that Gail mentioned, maybe, in fact, the goal here was to help English language learners. English learners, that's a categorization that exists in existing law, which all of our federal funding recipients have to track and report to the Department of Education how many of your students are learning English. One thing you could do would be to say that all funding that in this program to replace the HSI programs would go to help specifically meet the programming needs of English language learners, rather than just being spent to benefit Hispanics and others, knowing full well that, by the way, a vast supermajority of American Hispanics prefer to communicate in English. The last statistics I saw on this had the number above 80%. So you want to talk about somewhere where, if that's what they think they're doing, it's not narrowly tailored, relying on what can only be described as a decades out of date stereotype has got to be a good example of that. We also had an option of replacing these programs with block grants, especially if you're trying to shut down the Department of Education. That might be appealing. You could hand money to the states to spend how they want, either generally, or no, you could hand money to the states to spend how they want. We offered 2 different formulas you could use for how to break up those block grants. Either you could base it on, frankly, where the money's already flowing through the existing programs that are unconstitutional. Yes, that has embedded problems, but it might be easier to get through Congress. The other option that we gave was you could pay attention to the Pell eligible student enrollment numbers by state, because you already have that. And that might be a good way to do this, especially if what you're really trying to do is to increase the access of students in need. I'll also point out that while there are certainly people who think that anything that has a disparate impact is unconstitutional, I am not one of them, and that that I don't care whether something has a disparate impact unless it was enacted in order to achieve that disparate impact. And if that's what, in fact, the law says, then this money will flow to Hispanics or other groups that are more at need, or are perceived by some to be more at need, to precisely to the degree that they are right. If, in fact, but by the way, it would also be much better targeted in only helping the people who actually need the money. Dealing with another one of the issues Gail had mentioned. The last of our choose your own adventure version of this was basically to merge version 1 and version 3 to say you can block grant this in either of these or in any other allocation formula you like. And over the course of a number of years, I think we picked 5, sunset the block grant program and shift year over year over year the money in fifths from where it's going in block grants into the Pell Grant program. So at the end of the period, you have a program that's actually helping people afford college. You could do it a lot of ways. Those are just the ones that we came up with and suggested.
Thanks, Dan. Gail, so why is socioeconomically based federal assistance to universities and colleges better than race or ethnicity-based assistance? How can organizations, watchdogs like us, legal advocates, and other stakeholders monitor future developments regarding this issue to ensure that schools don't engage in the use of race proxies?
Yeah, I mean, one obvious reason that socioeconomic class is better than race is that like it's constitutional, but it's constitutional for a reason. And that is that you know, to give people help based on the fact that they have low income is a much more sensible idea, and it doesn't have the same edge to it because if you're a low income student and you come from a family that hasn't made a lot of money and you're able to get some help to get higher education, at the end of that process, you're going to be eligible for a better job. And guess what? You're not going to be low income anymore. And that's the whole point here, that we're trying to lift people out of poverty. And while race is something that's permanent, ethnicity is permanent, and it runs in families. Socioeconomic class, not so much. The whole point is this would be a program to lift people out of poverty. The danger, of course, is that, and many states have been doing this, is they will say, look, we're not engaged in discrimination on the basis of race. We're giving preferences and admissions based on socioeconomic class. And then they define socioeconomic class in a way that is very clear that they're really after race. So instead of just basing it on income, they will base it on, what neighborhood do you live in? What's your zip code? Knowing full well that some zip codes are going to have one, racial makeup and another zip code will have another racial makeup. And, you get these complicated formulas that are all about really targeting race while you're pretending that you're targeting socioeconomic class. And that's a real danger. And you don't want the federal government to start doing this the same way some of the state universities have started doing this, particularly in those states that prior to the Students for Fair Admissions case, they already had a state constitutional amendment that prohibited discrimination by race in admissions, preferential treatment by race in admissions. So I think what's going to have to happen is that organizations like Californians for Equal Rights, they're going to have to be very, very careful and monitor, what's happening in 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 these federal programs as well as in state programs, and it's going to be a long, difficult process. The federal program is probably going to be the easiest to monitor, to make sure that nobody gets in there and tries to come up with a definition of socioeconomic status that's really targeted at race. Because I think we're going to be able to get the information about exactly how they're defining this. But we got to do it at the state level too, and at each university level. And one of the good things that's happening at the Department of Education is that they are trying to get data out of individual universities now that will help them assess whether or not there is hidden discrimination. And I hope that organizations like CFER and like the American Civil Rights Project and lots of these other organizations that are concerned about this issue, I hope that all these organizations are vigilant to make sure that we don't allow colleges, universities, state governments, federal government to turn socioeconomic status preference into race preference.
Yeah, eternal vigilance is the price of liberty.
Absolutely.
And under a friendly Department of Education. So,
Yeah,
Adam, last question from me. the policy landscape at both the federal and local levels is constantly evolving and changing. At the national level, it is contingent upon results of general elections and subject to political cyclical changes. What can proponents of for equal protection do to consolidate the policy victories against HSIs?
Thanks for that question. First, just a quick detail. Dan is right that for the HSI programs, you do have to be able to show that what you are spending the money on is supporting Hispanic and low-income students. That's easy to do if you're building capacity for all students. You say, yes, Hispanic and low-income students are part of that population. In fact, a big part of our population. So that's an easy way for them to meet that requirement, but they still do have to do it. So just drawing out, Dan is also right. There's a bunch of different things that Congress could do. Heritage's view has been dismantle the department, and probably all of Title III and V, other than HBCUs, needs to go anyway. But Dan's options are all legal. The problem is they're politically challenging, right? So it's very difficult. It's a political loser to say there's this identity group that's been getting all this money, and from now on, they're not going to get that money. It's just going to be a block grant that's not going to include that identity group anymore. So working through the legislative branch is going to be a challenge. So I think the winning model is what's already been happening, is going through the judicial branch to make the case and win the argument, and let the chips fall where they may after that. Now, if you did want a legislative victory, maybe you could do it indirectly. Let me try this one sentence bill on you. Notwithstanding any other provision of law, every eligibility requirement in this code for any purpose that is based on race, color, ethnicity, or national origin, other than being American, is void and hereby rescinded. So you're not actually targeting a particular grant program. You're just saying anywhere where that kind of discrimination exists in our laws, it's gone. Maybe that can work. Probably still doesn't work. So if you tried the executive branch, I think we're in a good moment, because it was amazing that the Department of Justice actually said, yes, we agree this is unconstitutional. We're not going to be on the side of the defendants after all. I had heard that they were not interested to go there, but since Tennessee took the first step with some plaintiffs, I think it provided some air cover so that DOJ could go second and say, actually, Tennessee, you guys are right. So now that that dam has been broken, we maybe can see some executive agencies do the same thing at the state level. So in Florida, for instance, there's a Jose Marti Scholarship Challenge Grant, where only Hispanic students and students of Hispanic cultural heritage are eligible for this scholarship. So will the Florida executive branch, if they get sued, do the same thing that DOJ said and said, yes, the state legislature of Florida gave us this unconstitutional program. We can't defend it. That'd be very interesting to see if we can get that to happen in Florida. And then finally, court of public opinion. So, the idea is to continue to make non-discrimination in these areas politically acceptable, and not think of reverse discrimination as somehow a different category. And the usual rhetorical strategies, right? You have a victim with a compelling story. Think Riley Gaines in the Title IX context, right? Somebody, all he's trying to do is get his education. His college is poor enough here in West Virginia, say, but not Hispanic enough. Look at all of this money that's not going to his school. It's not going to help him because his colleagues are the wrong race. Try to tell those stories. And I'm going to try to tell that story for West Virginia, try to quantify how much money are our West Virginia colleges losing by being poor enough, and they sure are, but not being Black enough or Hispanic enough or Asian enough.
Thank you, Adam. I'm sure our meeting attendees all appreciate your insights on this important topic. I'd like to open up our floor for a quick Q&A session. If you have any questions for our panelists, please write them down in the Zoom Q&A window. We have so far 2 questions from Kathy. If the federal government doesn't fight this case, will there be a decision that serves as legal precedent? Can CFER take over and intervene to make sure a decision comes down that outlaws this HSI designation and funding? So Dan, you've represented CFER in in some lawsuits. So can you take this question?
Sure. I think that this is why it's important that HackU has tried to intervene as a defendant, because whether or not DOJ will defend these obviously unconstitutional programs, assuming the court lets them in, someone will. And we're going to, in fact, get a merits ruling which they will have every incentive to appeal when they lose, and which means that we'll also get rulings higher up as well.
And can CFER intervene?
Um, I don't know that CFER would ever want to intervene to defend these programs, but it's something that they could think about. If they were going to talk to someone about that, it would be important that they discussed it with lawyers that aren't me or Gail, because we're obviously conflicted while we represent the other side.
Understood. Okay. Next question from Andres. Thanks for the interesting discussion. What roles can professors or staff within universities play? So, Gail, you just retired from University of San Diego, and Adam, you're still teaching at several universities. Will you both take this question?
Sure. So if you want to be a whistleblower, you have whistleblower protection, very likely. Make sure you talk to a lawyer and figure out what you can say and who you say it to in the right order in which you say it and to whom you say it. But you're going to have very specific information from the inside, maybe documents, maybe policies that are not written down, but that happen anyway. And you can let the appropriate people know and make sure that you're protected. And then you could even file a False Claims Act claim that hasn't been maybe well tested enough, but you get some of the money if you can say that your university has lied to the government and unlawfully gotten money by saying it doesn't discriminate, knowingly discriminating anyway. So the federal government might intervene there and take over the case for you, in which case you still get a bunch of the money that's recovered. So you can file a False Claims Act case. But again, I'm not an attorney. You're going to want to have one in both of these cases.
Let me just add a little bit here about the HSI case in particular. A few months ago, Dan and I were desperately trying to find faculty members to be part of our motion to intervene on behalf of the NAS and on behalf of FASORP. And in particular, we were looking for someone who would be an academic at one of the Tennessee schools that the Attorney General of Tennessee was purporting to represent, because we wanted to be able to say that, in particular, in our motion to intervene, we are representing the interests not just of students, but also of faculty. And, because that made us different from Students for Fair Admissions, which you can tell from their name. They focus on students, whereas the National Association of Scholars focuses on faculty. And so, it's very often the case that in order to make an effective lawsuit, we need somebody who is a professor at a particular school or a particular group of schools. And, what we need is a network where we know that there are people out there at particular schools. So if you join the National Association of Scholars, or if you're a law professor and you join the Federalist Society's their law professor section, or you join one of these organizations that tends to attract academics who have a more conservative or libertarian outlook, that makes it a lot easier for us to find you when we need you.
Just to be clear, Gail, although it's subject to each individual state's laws regarding legal standing in cases like this, can we say that by and large, professors or faculty members' anonymity will be generally protected in a lawsuit like this?
It's hard in the sense that, yes, we can ordinarily effectively protect the identity But I can never say absolutely positively. As a lawyer, I have a duty to my client. And if my client, really wants to be anonymous, can I ever say that, like, absolutely positively, there's no doubt about it, your identity would never be revealed? I could never absolutely do that.
That's fair enough. Thank you, Gail, and thank you, Adam. Another question from Yvette. I am a trustee at the California Community College that is a designated Hispanic serving institution. Do you have any suggestions on how I can address concerns regarding Hispanic serving institutions?
Look, I would say that if the money is there, it's very hard to say to the rest of your institution on principle, let's not take the money that 600 other institutions are taking. But what you can do is say, I want to find out about the admissions policy. What do we actually do? And let's see the data. I want to see, what do you do for summer bridge programs? Do you advertise just to the neighborhoods that have Hispanic students or not? So just try to get in on the programming, the kinds of things that the college does for recruiting as well as admissions, and try to, by asking good questions, see if you can figure out whether that's designed to change the profile of the student body through a proxy rather than even if they're not doing overt discrimination.
Can I throw out another suggestion there? Pay attention to scholarships that your school gives out. What are they funding? And not just what are they funding in their own name, but what are they funding through the school's supporting foundation or any other foundation with which it is in contact. Pacific Legal filed a case, I don't know, within the last month, I believe, against UCSD and the San Diego Foundation, alleging that they have been conspiring to get around Prop 209 since 1997. That at that time, the school took all of its race-based scholarships, offshored them into the foundation, and has been telling the foundation ever since who to give grants to. I don't want to say that that's a common move, but it is certainly a move that since Harvard came down, we've seen elsewhere of those claiming that it's not us who's discriminating, it's us in drag as a foundation or our alumni association, but that's wholly different because they don't get any federal money. I don't know if your school's doing that, but I think it's worth asking.
I just want to emphasize the last step here, and that is, after you've made these inquiries and you've found something, get that information to us. Get it to Wenwan, get it to Dan, get it to Adam, get it to me. That's helpful to us in litigating these cases and generally talking to the public about these cases, to let people know that incentives like this do lead to discrimination.
Thank you. While we wait for more questions, I have a follow-up regarding the colleges in California. So 2018, the University of California, Berkeley announced its intent and the strategic plan to pursue HSI. We wrote a letter pointing out that this is going to be in violation of Proposition 209, and this is also highly likely unconstitutional. The school's vice chancellor wrote back right away within the week, promising or pledging not to employ any racial quotas or engaging in any act of racial discrimination in their student selection. And they emphasize that the school's pledge to achieve the HSI designation is only going to be done in ways that comply with both state and federal laws. So, how sincere do you think UC Berkeley is?
UC Berkeley has a history of not being sincere on these issues. So I would have a very hard time to believing that they have a strategic plan to accomplish the goal if it doesn't include discrimination. I mean, if they were just saying, we'll sit here and wait and see if we eventually get to 25%, that will be one thing. But the fact that they even have a strategic plan suggests to me that they're intending to discriminate. And for decades, the University of California has been less than sincere on these issues. Even before Prop 209 passed in 1996, Ward Connerly, who led the Prop 209 campaign, was a regent on the Board of Regents governing the University of California, and getting the information about how they discriminate was a major, major battle. They lied outright to him. So, like, is it possible that they've become really sincere? I guess it's always possible, but don't bet the ranch on it.
I would bet anything that they are sincere in saying that they will have an opinion letter from their lawyer that the things they are doing are consistent with their legal obligations, which in no way means that they are sincere, that they are actually complying with their legal obligations.
Thank you. Another question from Kathy. How is the state of California exempt from Prop 209 through these HSI designations? And in other words, also another follow-up from Kathy. How is it legal for K-12 school districts like LA, USD, and other California districts, and possibly other states or other government agencies to be directing funds by race to Black student achievement programs, etc.? What can be done here?
Yeah.
And we just had a new law in 2023 passed in California regarding the Black serving institutions designation. Can um, can you talk about all these the interconnections between federal and state laws in connection with the new law on Black
Yeah,
serving
one
institutions?
interesting thing about Prop 209 is that when it was drafted, it includes a section that says that if it's necessary to qualify for federal funding, and if it's necessary, then you can discriminate or grant preferential treatment based on race, et cetera. And the proper response to that here is that in order to qualify for HSI status, there's no requirement that you discriminate, so that it shouldn't involve that. But nevertheless, a school could qualify for HSI status despite Prop 209, in the sense that they just happen to have 25% Hispanic students, and that's just the way it was demographically. So I don't think they have to then refuse the money on that account. They can take it. They cannot discriminate by race in how they spend the money. They can't say we're only going to spend it on Hispanic students. But they can be an HSI and still be in compliance with Prop 209. That doesn't mean they are, but it's at least theoretically possible. You point out this new program by the state of California that I have not had a chance to look at yet, but it evidently designates certain schools. Is it Black serving? Is that the term for it, Wen-Wen?
Yes, Black serving institutions.
Right now we don't know exactly what California plans to do with this. It almost sounds like it's a designation that has no purpose. That, like, you get the designation, but it doesn't get you money, it doesn't get you anything. In which case, arguably, it's not a violation of Prop 209. I mean, you could make an argument that somehow this is a valuable designation just because it sounds nice, and that therefore there's a problem. But, like, we got much bigger problems than that to deal with in the law. But my guess is the intent is at some point down the road to fund it. And if it gets funded, or some other thing happens that makes it a real advantage to be designated as a Black serving institution, then that's going to matter. And I think that's probably the time for the lawsuit.
Thank you, Gail. Do you have anything else to add, Dan and Adam?
Yeah, I mean, the short answer is that those things are just straight up illegal. And once they have money, now the Black serving Black serving institutions at the California level doesn't. So, wait for them to do anything. But like the LA Unified School District, it looks almost exactly, to be honest, like a state level version of the HSI programs with a different beneficiary. And all the issues are the same, plus U of 209. And I assume someone will litigate that.
And the benefit wouldn't have to be extra funding, it could be anything. If there's a benefit that you get from being a Black serving institution under California law, even if it's something like the governor will give the commencement speech at your school, but not at other schools, whatever. If it's preferential treatment on any basis, then it's illegal.
But again, I mean, it is true that there are schools that organically qualify. I mean, there just are. Like, there are areas of South Texas that are 90% Hispanic, when UT Rio Grande Valley has an 85% Hispanic enrollment rate. Is that because they're discriminating in order to access the HSI program? No, no one would say that. It would be absurd. But, the problem here for the spending clause front isn't whether there are any recipients who have done nothing wrong. It's whether the federal government, through its spending power, is incentivizing violations. And the answer there is that it very clearly is.
Yeah, I don't even think you need the incentive. Even if every school, were absolutely set in stone what their racial demographics are. Again, flip it. Even if every school was going to have the same demographics from now until kingdom come, you can't have a program that says we give money to schools that happen to be 70% white, or whatever the sort of numerical equivalent would be for HSIs. I mean, note that HSIs require 25%, which is higher than what you get in the population at large. And you could say, any school that has more than what you expect in terms of white students gets extra money. No, we're not going to do that. That's clearly unconstitutional. And it doesn't matter if you change which race you're talking about, it's still unconstitutional.
Right. It's an equal protection violation regardless of the incentive effect. The incentive effect is additive rather than the only thing present. I mean, like,
Yeah.
it is federal racial discrimination, which on its own, full stop, they can't do.
Yeah, the thing about the incentive argument is that, I don't like it as well in terms of being the basic argument, because then you got to prove that they've actually acted on this incentive. And I think they probably have, but like, I don't want to go there. And you have to also prove that this was intended. And like, I don't want to go there either. It's much easier to say you just can't do this, to give schools, money based on the race of their students. It's important to add the incentives, because I think that makes people understand just how serious this is. But my point is, even without the incentives, even if we knew that every school was just going to stay the same racial demographics forever, it's still unconstitutional.
Adam shared a link of a news article regarding the discontinuing of the Black Students Achievement Plan in LAUSD as a result of an administrative complaint. I believe that was filed by Parents Defending Education a couple of years ago. However, I am also aware of another program within LA Unified called the PHBAO, predominantly Hispanic, Black, Asian, or other non-Anglo program. Although it's not a program for competing for extra public or school district funding, it offers things like class size reduction and extra parent teacher conferences at the schools that qualify. So I would think that's a racial preference there, and should be unconstitutional. So it's still a story that's developing. So I'm closely following that, and hopefully we can update everyone on this very soon. With that being said, I want to thank all our panelists for taking your time out of your very busy schedules for our webinar today. Thanks to all who have joined us in this thought-provoking discussion. In the coming weeks and months, we will be hosting more webinars and addressing a variety of timely topics on education, law, and policies. Thanks again, everyone, and see you next time.